right, so it's 7:05, and you're all welcome to today's edition of the Lawyer's Diary. Last week, I know a lot of people participated, and we are grateful for your time and attention. If you've not subscribed to any of our social media pages, I've displayed our social media handles on our screen. On Instagram, we are Lawyer's Diary Global. On Facebook is the Lawyer's Diary. And then on YouTube, it's Lawyer's Diary. What we do is that after every session, we upload the videos on YouTube. And then also Instagram for an update on the upcoming programs. Every weekend, we bring you very interesting discussions on general happenings, interesting discussions on legal issues. So we pray that you get the time to subscribe to our social media page so that you get to know any upcoming program that we may have. Today's discussion is on medical negligence and the rights of a patient in Ghana. Many times we ask whether even patients in Ghana has any rights in the legal field. Or if you go to the hospital and something happens to you, do you have any legal remedies at all? So today's discussion is purely on medical negligence. If I go to the hospital, come back home, later realizes that the doctor failed to do something which he ought to have done. And then because of the failure to do that, I get to have some complications in my body. Do I have any remedies in law? If I have complications, if my mother has complications, if my friend has any complication, who has the legal capacity to even sue? And then, are there any time limits that bars me from instituting or having any legal rights? And then we'll talk about some of the challenges that the doctors have. So we have two guests today. Our guest on the legal side is no new person, lawyer Edwin Kusi-Appiah. Lawyer Edwin is the head of legal and managing partner of Kusi-Appiah and Associates. He has done extensive research on medical negligence and has been seen on various television and radio stations expressing his ideas on medical negligence. And then on the practical side too, we have Dr. Nathaniel Oforiatta Sr. Dr. Nathaniel works as a medical doctor at the Ketu South Municipal Hospital. He's also a CEO of Action Denominators Group and then a global speaker on Superlife. So, Lawyer Edwin, welcome to today's edition of the Lawyer's Diary.
Thank you, sir. It's always a pleasure to be for our participants. It's an honor to meet you all today. And like I said the last time I was here, we will try to make it as interactive as possible, where it does not become a teaching session, but a place where we all learn and walk away from here with knowledge. So thank you.
All right, and Dr. Nathaniel Ofori, welcome for today's edition of the Lawyer's Diary.
Okay, it's been a warm, pleasing pleasure as well as a privilege connecting with you all. Currently, I'm in Kumasi enjoying some sabbatical leave, but I'm also an entrepreneur, so I have various teammates globally that I connect with them through Zoom. So I hope that you get to see that in this world, we are now living in an evidence-based era. We've stopped that era whereby presumptions rule. And we will try to give some data on how many of our cases, because we don't have data to back our presumptions, it goes out to the dust. But if you have data to prove your case, you can make incredible income in the Ghanaian community. So thank you for having us all. We also try to show you some of the challenges because many of the lawsuits that come fail to acknowledge the challenges we are having. And they look at the face value of things, but not the practical value of things. And you try to lay bare the practicality on the ground, and then we all put it together and make an informed decision when we want to take a lawsuit against a hospital. So thank you for having me.
All right, thank you very much. All right, so we'll go straight into the reason why we have all gathered here today. So I'll start with Lawyer Edwin. Generally, when we talk about negligence, can you explain to us the concept of negligence? What is negligence? And by popular request, we've had some feedback that if we can blend the language, the feedback that we had was that you're going purely English sometimes restricts the audience. I mean, I'm sure majority of the people here can also understand Trinity.
Okay. Thank you very much. Negligence is a tort, essentially. And when we talk about a tort, we are talking about an action or an injury that is occasioned to a person or the property of a person. And therefore, negligence has been seen as a tort, where if you need to prove that somebody has been negligent to you, then there are three essential elements that you have to prove. The first is that that person owes you a duty of care. And for the sake of our discussion, I'll go straight into it. If a patient walks into a hospital and picks a folder and pays for consultation, it means that he has established a relationship with that hospital where he has now become a patient of the hospital. So now that hospital owes that patient a duty of care to take care of whatever ailment or problem that the patient presented to the hospital with. Now, the second element in proving negligence is that that duty of care that the person owes you was breached. So another example, the patient having become a patient of the hospital because he has paid the gotten a folder, paid for consultation. Now, when he goes to that hospital, the hospital misdiagnoses him, treats him wrongly. If it is a surgery that is going to do, that surgery was done badly. And then the third element, that because of that breach, that person suffers an injury. So if it is a surgery, the surgery was done wrongly, or if it is a surgery, something was left in the stomach, and because of that, it has caused another problem. Now, for anybody to prove negligence, that person, as I stated before, must show that there was a duty of care between the two persons, and that the one person breached that duty of care, and as a result of that breach, an injury has happened. This means, therefore, that if you prove one element and not the other two, you cannot succeed if you are going to court for negligence. If you go to the hospital and the hospital, you take a folder and everything, the doctors take a look at you and even they make a mistake, but you do not suffer any injury because of the mistake, you cannot be successful in asking for a negligent damages. If at the same time, if the injury that occasioned you was not because of the breach of the doctor or the breach of that negligence, again, you cannot succeed in a suit for negligence.
Okay, so I mean, per your explanation, there are three elements. There has to be a duty of care.
Yes.
And that duty of care becomes evident when you make payment. But lawyer, you know that in a typical setting, we went to nearby hospital, the person doesn't have money.
Yeah.
And out of pity, the hospital voluntarily assumes the responsibility of assisting the person. So is it a case if I don't pay money for a folder, for a hospital card, there can't be any instance of duty of care, even when the hospital or the doctor can say, oh, we do Niska, but Mama.
Oh no, the moment the hospital assumes that burden, that we are going to take care of this patient, that hospital has taken on that duty of care. And let me expand the duty of care, because sometimes, by what I have said, somebody may think that if a patient walks in an emergency situation and has not gone to pick a folder and whatnot, the hospital has a right not to attend to the person. The hospital has placed itself in a position to give care to all people who are not well. So if a patient enters the hospital, apart from the fact that they have picked the folder and everything, immediately a duty has been established that that person has come there for caregiving. Like you said, if it is indeed the hospital has assumed the burden, the patient does not have money, but the hospital has itself assumed the burden to take care of the person, it doesn't matter. If it breaches that duty of care, it will, and injury is occasioned the patient, that hospital will suffer for it. But additionally, if a person walks into a hospital, has not even taken a folder, and comes before the hospital has a right to has a duty to take care of that patient, except if it does not have the facility or the competence to take care of that patient, in which case it has to immediately refer or transfer the patient to the nearest place. In that case, it has not assumed the burden and therefore established a duty relationship, with the patient.
My point is also on the duty of care, because that is the first element that you need to prove, that there's a duty of care, that duty has been breached, and because of that breach, a hardship has been occasioned to you.
Yes.
In an instance of emergency,
yes.
In an instance of, say, an accident, when exactly does that duty of care, which is the first element, come in?
Yeah, that's what I am saying, that the moment a hospital puts itself out as a place where we attend to people who are ailing, it has established a certain universal duty to everyone. When a patient comes in and at that material moment is in an accident, that person does not necessarily need to pick a folder and to become a patient. If the hospital will not assume that burden, it must immediately refer that patient from the hospital. If it keeps the patients there with the impression or assumption that it is going to take care of that person, even though the person has not taken a folder, etc., the hospital has put itself out to establish that relationship between itself and the patient. So essentially, it is the way the hospital puts itself out, and of course, the fact that a patient has himself established that relationship with the hospital, that establishes that initial duty of care.
Okay. So, I mean, as you explained, it means that there has to be a duty of care. I know people just joined us. The duty of care must be breached by the medical officer. And because of that breach, a certain hardship is occasioned to you. Yes. Let me give you a typical example. A doctor assumes to help a patient. The patient doesn't pay anything. In the mind of the doctor, or papa is even doing a benevolent action or favor to you. And in the course of doing that, you face some complications. Would the doctor still be deemed in law to have been negligent?
Yes. If the doctor assumes the burden to take care of the patient, even though the patient does not have money, he does not have the right to give standard care because of that. So while doctor ni uji tu say nipa no nisika ne mom mehwe and chrese onisika ntino ubehwe ni biara. It means that you are assuming a duty, and that duty will be judged by the standard that is required of any doctor who is taking that, who is giving that care to to that person. So a doctor cannot ever say that because somebody didn't pay, I'm just giving the person any substandard care, because the moment he does that, he has put himself out to be sued for negligence.
And it's a very serious matter because, recently there was a report that came out saying, according to the doctor-patient ratio in Ghana, one doctor is taking care of over 10,000 patients.
Yes.
And even on a daily basis, over 2,000 patients visits one doctor. And anyway, they spend over between 17 to 25 minutes on a patient. That is very overwhelming.
Yeah.
And so if a patient walks up to a doctor, the doctor is tired. There is no relieving doctor, and then there's an emergency. The doctor is going into that, say, surgery with a tiring mind. Would that doctor still be deemed to have breached that duty you are talking about, even though he was overstretching himself to assist?
Yes. When it comes to negligence, if the doctor caused a problem intentionally, or even if he caused the problem by way of mistake, negligence only looks at three elements: that there was a duty of care, that duty was breached, and the person has suffered because of that breach. It doesn't matter that it was a mistake. Insofar as the breach, there was a breach. So back to your example, the doctor is tired. There are other avenues to correct that. The doctor can refuse to work because he's tired. He can take in naps.
But in an instance where, say, Dr. Nathaniel will come in.
Yes.
A doctor is tired. He sees an emergency being rushed to the hospital. The person will die.
Yeah.
But because he has sworn to defend, he has sworn to save lives, he says, okay, even though I'm overwhelmed because I'm being in a consulting room from, say, evening 6 p.m. to the morning 8 a.m. I wasn't coming coffee, but I can't also leave this patient. That's it. With a tired mind, I go to assist, and then there's complication. Now the law still says I'm negligent. Would I be wrong if I say that upon the emergency coming, I will say that personally I'm tired, so there's no legal obligation on me. Probably ethical obligation, but there's no legal obligation on me to do it. That's a required. Why would I want to put myself into trouble by trying to assist?
When it comes to medical negligence itself, I think we'll go into that, because the courts have held that in order for a person to prove that a doctor has been negligent, there are a few things that that person has to prove. I think I will get to that in a short time. But to your question, if a doctor is tired but sees an emergency situation arising, and because of that, he needs to help, it is all well and good. But that in itself will not absolve him, and by vicarious impression, his hospital, if that doctor acts and breaches that duty of care that is placed on him, upon which an injury has been occasioned to the person. That's why I was trying to explain that if a doctor has to put himself in that situation, there are certain few remedial steps that he needs to take, because I understand that it's difficult in our country. The doctor to patient ratio is rather high. But it does not mean that if you have been working straight for 20 hours, you continue to work regardless of the fact that you could route a very, very damaging consequence out of your tiredness. So there are simple things that can be done. But I guess the major point is that he cannot hide under the cloak of tiredness as an excuse for negligence, because the law does not admit of mistakes. Otherwise, everybody will claim that they acted negligently, mistakenly. You get it? So it does not admit of that. At very best, it may limit the damages that will be placed on a doctor, because if he explains to the court the mitigating circumstances of him being tired but needing to act because of the duty that had been placed on him, perhaps when they are assessing damages against him, the court will think about how much to do that. But by all means, it will not absolve him completely for him to say that I was very tired and I needed to act. Therefore, excuse me of any negligent act thereof.
Now to Dr. Nathaniel. I mean, practically, you've been in the hospital for a number of times, and I'm sure you've been faced with some of these things that we are discussing. What are some of the practical instances which doesn't make doctors act the way they are supposed to act?
Okay, thank you for that question. I hope my voice is audible. Now, yes, as doctors, we use data to make some of the decisions most of us would want to make. Now, let me give you some few data. June 15th, 2020, Mustafa Mohammed sued Ridge Hospital because his wife died on account of thromboembolism after cesarean section. He didn't go hospital, no, he didn't go operation, cesarean section, a year after operation, the wife died. And the claim said thromboembolism. So your operation here, the blood that is flowing, some can form clot and be circulating, and it can cause breathlessness after operation to CU hospital. No? That is number one. 5 days later, June 25th, 2020, the director of Ghana Institute of Language, Dr. Emmanuel Kusi, also sued Ridge Hospital on account to say there was wrong prescription given to the wife, and the wife died. He complained that the wife was not feeling well. A doctor came to review and realized that a medication that was not supposed to be part of the post-operative care was written by a junior doctor, and it became an issue. He publicized on his Facebook wall. Now, the third is College Teaching Hospital Dr. Nana Usu Prempe also sued the hospital on account to say, or the North Africa Hospital, Udru Hana, Dr. Nakata North Africa, he was shocked because the doctor didn't check that the vitals of the dead patient. They didn't do any resuscitation. The doctor just looked at the client, looked at the eye, and just told him, say, North Africa. So now, if you're a doctor, and you hear all these stuff, is it true, say, Dr. Nanyana Juma, and I say he could have done something for which, because the patient family don't understand the clinical evidences available, he will know. So, first of all, of course, vitals are important. We even use the vitals to classify who is an emergency or who is not. So in medicine, whilst we were being trained, you told us, simple, once somebody is shouting, it means he's alive. If microphone accident near the mobile emergency, they are all casanatias. Those that are quiet are those that are dying. So if a doctor, you see a doctor because you brought your client and he was shouting that the fact that he's crying means that he's alive. It's those that are not shouting, that we first go and check their vitals and see if we can resuscitate them. So the challenges are many. One is understaffing. Now, WHO did their research and realized that in 49 countries, in which all these 49 countries had low economic status, doctor to patient ratio was 1 to 10,000, meaning that no matter how many doctors you train, the gap is too wide. So in terms of personnel, it doesn't matter if we mention the specialty, pediatrics, oncologist, radiologist, cardiologist, optometrist, and all those things, the doctor-patient ratio is too large. And see, if you're a young doctor and you enter the practice, you are given responsibilities above your expertise. And these are some of the things that causes the challenges. And if a case comes and you think it is above you and you are calling your senior colleague, a senior colleague probably is on call. So you need to communicate with the person. Some junior doctors need a senior doctor there to even see whether their diagnosis is right. Because just as you were asking my learned colleague Edwin Kusi-Appiah about some of the negligence with relation to tiredness and all that, in 1964, two doctors in India, Dr. Balskrini and then Dr. Lakshma Krishna Baha, they were sued because of three things that they didn't do. One, if you're tired, but you make a decision to take care of a patient, it puts you under a duty of care. Now, the standardization should be there. Once you claim a patient, say, the standard operation procedure, was it followed? And the third is, did you check whether the administration of your protocols were done? So you can be a doctor, right, and then the medications were not administered. Even though the standard is there, you the doctor did your part, but the administration of the medication were not done. And some of these things, as a medical doctor, hypertensive medicine, diabetic medicine, malaria medicine, and all those things, once you write it, it comes naturally. You don't need to remember. And now you write medication, you are looking for family members. They are nowhere to be found. So the patient lies down for 8 hours, 10 hours, and everything is by insurance. So if you go to the hospital environment, most of the pharmacy, the records is computerized. So even if you pick a folder and jot things down, they want to know who is going to pay. So if as a medical doctor, I looked at one patient, the system demanded that I should pay, and I didn't, the patient's records were not there. So we can just give patient 001, patient 002, patient 003 in case of mass casualty and start treating them on numbers. And their identities are identified and we put their details, but who is funding it? So some hospitals have a policy. Let's say any patient that comes in case of emergency, the hospital is willing to spend a minimum of 1,000 Ghana cedi on that patient. Exceeding that amount needs to be paid for by any relative. And that's duty of care to the hospital, according to probably the hospital policy, is within probably 24 to 72 hours. So if after the 24, 48 and 72 hours, no relative come to show up, then they relay the information to social service workers that they should intermediate between the patient and the relative outside to bring in more income. Now, let's look at some of the technicalities. I want to use accident. If someone has an accident, the fact that she's talking that she's okay is not evidence. You need to take CT scan of the head to see if there's no bleed in the head. You need to take X-rays of the neck, the chest, the backbone, and the wrist, and even the long bone, the leg and the hand. Those require money. In hospital management, when these gadgets are spoiled, you need to maintain them. And so the hospital might be gathering data and realizing that they are losing much money on the pretense of emergency. So they also bring a policy that if the patient comes and it is an emergency, they will prefer doing X-rays than CT scan because some X-rays cost about 500 Ghana cedi. So the hospital management fund for a patient who is unknown, which is 1,000 Ghana cedi, if you want to do CT scan, it's going to take huge sums of it. So they want to stabilize the patient. In stabilizing the patient, we use what we call ABCDE. A is you check the airway. If the airway is not there, it means the patient will die. So as a medical practitioner, if a patient comes to the hospital, I want to check the airway. There are instruments you need to check the airway. One of it is called pulse oximeter. They usually put it at the fingertip of the patient. So if the hospital do not have, if batteries are dead, if they are old ones and they are faulty, the readings are different from what your clinical evidence is showing. So example, you see that the patient is getting sinus, meaning that it's not getting much oxygen. So you want to give the person oxygen, you put pulse oximeter there. The pulse oximeter says it's 99%. So you document that the patient doesn't need oxygen based on your findings on the pulse oximeter. So if the pulse oximeter is wrong and you don't use your clinical judgment, you think that the patient is okay and the patient will die. So some of it is updating of our equipment we use in the hospital. Number two, ambulance service. Before now that most people shouted about ambulance service, if you refer a patient from your unit, probably a district hospital, regional hospital, you want to take it to a tertiary hospital, Kolebu 37, Konfuanoche, you need to inform the emergency department that you are bringing the patient to their facility, and they will need to give you a go ahead to bring the patient. If you just call an ambulance and the ambulance services take the patient to Kolebu 37 or probably other hospitals, they find some frictions between the emergency nurses with the ambulance service because they inform them you didn't inform us to prepare. They need to prepare the patient would need oxygen if he was going to go to theater, or specialist needs to be there, orthopedic specialist, whatever, to assess the patient before the necessary inputs are done. So there are so many challenges in the field. Abroad, you want to do enzymes. You just take blood sample, you go to the lab, it is done. Here, the patient goes to see the cost. He doesn't even come back to you as the doctor again. So if 1 week later he dies, and then the family comes to see the doctor and we look into the folder, every doctor also documents every single thing. So he writes today's date, the time he saw you, his findings and his plan. Then he seals it. So if you don't come back and we pick the folder, they'll ask, okay, the doctor wrote for these examinations, were they done? No, it wasn't done. So the gap is too wide, but the quality should always be there. Sometimes it's not just about the quality, it's about the facility. If you train a neurologist, it takes about 6 years after medical school to train him. If you post that person to a district hospital, he may not function because they don't have the gadget enough available for them. And many of the doctors who are specialists now want to work in certain parts of the country. They are either in Kumasi, Accra, Takoradi, or Tamale. The reason why many of our colleagues, senior doctors, want to work there is that sometimes you want a second opinion. In the district, you are the Oga there. So if you're making a mistake, there's nobody to even alert you that, no, I don't think this plan will work because the standard treatment guideline does not support this, or new evidences state that we should rather alter the plan of action. So if you are the only one there and you are doing the wrong thing, there's nobody to even correct you. So it's amazing that many doctors want to be around their colleagues that they can consult. Of course, if people go to certain fields, the experience also comes with time. But until we breach that contract, it's going to be difficult. And one of the things doctors fight for is that if there's a system in place, that if you're able to work in this district or local, government is willing to offer you this incentive to further your education or that you do well. And one of the things we learned in medical school is the Hippocratic oath. Our realization is happening that it doesn't matter where you are, there will always be sick people, whether they are in the village or they are in the city. Sick people are always everywhere. So doctors too want to be where sick people are and they are willing to pay. So if you stay in a village and everybody complains about money, then it makes your work difficult because you really want to help people, but you need them to do certain basic labs, but they say they don't have the money. So you want to be in a city where things should be done. For example, if you have a hospital facility where their labs are not functional, if you go to Kolebu, if you go to Konfuanoche, there are several laboratory facilities also there that can run the test within the next 30 minutes, bring you your results. You use that as a template to take the patient to theater, whether the patient will need 2 units, 4 units, 5 units of blood, awaiting surgery and all that. But now you just ask for a simple lab test and the patient says they don't have the money, go outside and they have to travel about 2-hour journey in order to do one lab test. And quality assurance is also key, because sometimes they go and do the lab and they bring the report and you, the doctor, don't even trust it. Because if it is coming from Medilab, at least it's accredited. But if they say Ocherebuache Laboratory Center, the laboratory findings alone is not adequate. So if you base your argument on that and it comes out that no, doc, why didn't you verify the quality of the lab before taking this patient there? All these things inform.
But there have been instances where patients have complained that they come to the hospital and tell the doctor, I have headache. The patient might think it's headache, but maybe it might be migraine, or he may have hit his head in an object. But the doctor just asks, and then instead of treating the sickness with a very effective drug, mild drugs and that causes another complication.
Okay. Thank you.
That is the first question. And the second one is that you said there are internal funds that the doctors or some hospitals use as emergency funds. Are those funds from the government, or they are the internally generated funds, and do the patients always pay back? Or once it is termed as an emergency fund, that's just it?
Okay, to answer your first question, when you grow in a practice of medicine, you tend to realize that most of the things you really want to address, you should consider who is going to fund it. So you as a doctor would have some data. How many malaria cases do you have? How many hypertensive cases, diabetic cases? So when you are going to stock pharmacy medication, you write the drugs that patients usually come to the hospital and complain about. And that is what they stock it, because many of the pharmaceutical products have expiring dates. So if you stock all these migraine medication and patients who come there don't afford it, it expires and they throw it away. So for some of the migraines and their medication, it's a little bit expensive. So we usually tell the client that, okay, madam, I'm thinking that based on your symptoms, based on your history, I think this medication will help you a lot, but the price is very, very expensive. Example, I'll give you a drug, like a drug that costs about 600 Ghana cedi. Sometimes if you say 600, people think it is 60 Ghana cedi reference you are making. But when rather they hear that it is 6 million, it blows their mind. They say, no, they can't afford it. So what the doctors do is that they write the medication for you, that if you have the money, go and buy it, and write the mild one for you, so that it lays them off from that negligence, duty of care. So the standard medication is written for you, but since you can't afford it, they write the ones that insurance can cover. And the insurance medication is also based on the common conditions governments can manage. For example, if you have malaria medication, a lot of children have malaria, so government would want to stock more malaria drugs. If you have a cancer, one treatment valve for cancer is about 1,000 Ghana cedi, and government cannot manage about 200 cancer patients in the whole of Ghana. So those medications are not covered. Even if they are covered, you see that this medication insurance pays only 1 cedi 50 pesos. For some of the people that take prescription outside the hospital to private pharmacies and claim that it's an insurance product, they say no, insurance only covers 5 cedis and the product is 30 cedis. So you pay the difference. So these are all factors that come into play. So cost is also important in managing patients. And one of the things I learned is that, you see, many duties are on medication. So even though the production of the drug, shipping it to Ghana, when it reaches the harbor, the duties on the product is so expensive that it increases the tariff on the product. So sometimes the donors make it cheap, but the patient not afford it until it is given. So you have many of NGOs footing many of these bills for common conditions.
All right, Dr. Nat, thank you very much for such an insightful...
for now. So, lawyer, thank you for the opportunity.
All right, so I'll be back to Lawyer Edwin. In Ghana, are there any rights of a patient? If I'm a patient, at what point can I tell a doctor that maybe I'm allergic to something, you can't give me this drug? What point can I tell a doctor that you are, I think you are giving me the wrong medication? As against the doctor also telling, no, there's a thin line between letting the doctor know what you feel and the doctor also letting you know that anyone have a chain. So are there any legal rights of a patient in Ghana? If I go to the hospital now, I step in the hospital, I pay my bills, they give me a folder. What are my rights in Ghana?
Your rights are many. And before I jump into that, I realized that in my earlier submission, I left out a key important thing that I need to bring to your attention. The courts have ruled on what will amount to negligence, medical negligence. And there are a good number of cases that exist. I'll talk about just one case, but first I would explain. The courts have said that in order for any patient to sue a hospital or a doctor and say that that doctor has been negligent, that patient must prove that the duty of care that was given by the doctor, no other doctor of even the least skill would have given that care if the doctor was exercising even ordinary care. I know it's confusing. Let me use small details to explain it. What the court is saying is this. If you are going to prove that the doctor has been negligent, you must prove that how he treated you, even a doctor with the worst skill will not have done so because in their line of training, they should not have, he should not have come to that conclusion. If this is a given, then it means that if you go into a hospital and they misdiagnose you, for instance, you are suffering from typhoid and the hospital treats you for malaria, that hospital has not been necessarily negligent. What you need to prove is this, that in the doctor coming to a conclusion that you have typhoid, no other doctor would have come to that conclusion given the circumstance and what you told the doctor. Minchira say wochi. Say, call hospital, I say doctor we why negligent. And man say, I was which say, send your doctor and share one. Doctor on ya dear crano, and he said, and call show, sir. And no, said call hospital. Now say, me tia dear. Say doctor for bio say, okay, we are typhoid. Obisu say malaria. Now say hospital be sure for malaria. Now question now come say na typhoid. Won't mean say the mom sure for malaria, no my negligent. A son say, I just say who prove say conditions now or the man. A idea we doctor for nyina ya mom training. Ni onya de wo mkra na ni senko or mouse our condition. So I'm saying it here. And
so let's use this example. Accident in impact 10 in a womb.
Yes.
May a doctor, my timia she must 7 and 3 3 and a bushia 4. Instead of assuming they need to test whether say would any doctor fixed in my position with the minimum of skill between 7 and so was I'm going to waiting 8 and 9 and I'm a then I'm negligent.
No, the law Nika said every care be audible. Did you come up to the standard that was required? Into 3 now, Omuyano. A woman said, why her 7 dear, but 3 now, Omuyano. Send you was sure. Was it so bad that even a doctor of ordinary skill would not have given them that kind of treatment? Because negligence is from person to person. let's say the three who somebody has died have a right to say that, okay, this doctor didn't treat our kin well. Now, for them to be successful with a suit of negligence, they must prove that the standard of care that the doctor gave to that their kin was so bad that in the ordinary training of a doctor, even the worst doctor would not have given that, come out with that condition. So let me tell you this story. Now, in the case of, it happened in Goldfields. It's Jan versus Goldfields. You know, Goldfields, they have these outstation hospitals or clinics, more or less like that. Now, a man takes his son to that hospital. Now, when he got there, the senior nurse was there. The doctor on call was there. But when the nurse looked at the child, the way I know running fever and everything, she assumed that the child was having malaria and gave her chloroquine. Meanwhile, the child was suffering from polio. And so because of that, the father sued the hospital. Now, the standard of the proof that was required of the father was to prove that what the nurse did was one that was so bad that no other nurse would have come to that conclusion, given the symptoms that the child presented with. And the court said that they were not able to prove that. Even in this case where the doctor on call was there and the nurse did not consult the doctor, the nurse was not found negligent because the law was that if you look at what the nurse did and if you look at the conditions that the child presented with, a lot of doctors would have assumed that that child was having malaria, and therefore that is why that injection was given. And so that nurse was not necessarily negligent. Of course, they made the hospital pay a bit of fine for the nurse not having consulted the doctor on call. But the point was proven by the court then that in order to prove that a doctor has been negligent, you must prove that the act of that doctor was so bad that no doctor of even ordinary skill would have done that, even exercising the least bit of care. So this is the standard that has been set now in the court. And the next thing is that it is equally not easy for somebody to go and sue a hospital if you are not going to get doctors that are going to testify for you. We know that the court, as good as it is not competent enough to interpret medical jargons and medical findings. And lawyers cannot interpret it as well. And if you sue somebody, you cannot interpret it yourself. So you need other doctors or another doctor to come and say that this thing that this doctor did was so bad and so negligent that he should not have given this to the person. Like what doctor said, when it comes to the man whose wife died at Ridge Hospital, I mean, he bears the burden to prove that the medication that was alleged to have been given to his wife was the cause of the wife's death. And that medication, given the symptoms that the wife presented with, no other doctor should have given that medication. If it turns out that a lot of doctors would give that medication for the symptoms that the wife presented with, he will struggle to prove the case of negligence against the person. And more so, I was hearing that if he has not already obtained the records of the wife before even starting the suit, it becomes even more cumbersome, having laid a claim which will become difficult to prove. Now, back to the actual question that you asked me, about the rights of a patient. The first right of every patient, you must always remember, sir, is that you bear the sole responsibility of your life. There's a difference if you are stretched into a hospital where you are not capable of knowing what is happening around you. But if you go into a hospital and you are live and kicking, as most of us do, we go there as outpatients, then you bear a responsibility in this regard. When you enter the hospital, you bear that responsibility to tell the doctor the truth about your condition, because the findings that they are going to be made is going to be assessed on the truthfulness of what you told him your ailment was. If you give wrong facts about yourself, and the doctor also gives you medication that turns out to hurt you, you cannot sue him for negligence. So that's the first.
Are there no obligations on the doctors to also probe further into findings as to whether the things that the patient has told me is the true state? An example is that I come to you, I tell you I have malaria, because to me, anytime I feel like vomiting, anytime I feel my hands are pale, there's malaria, not knowing it may be typhoid. Are there no obligations on the duties on the doctor to maybe run a test, at least, to find out that, do a urine test, blood test, to see, check whether there are mosquito bites or elements of something in my blood?
Yeah, yes. Let me attack the second part of your question before I come to the first part. Yes, there's a duty on doctors to run tests, etc., before they give care. But sometimes emergency situations can require of them to make split decisions to save life, and they may not have the time to do all those tests. Number two, we live in a country and in a continent where, like he was saying before, there are patients who don't have the wherewithal or even the inclination to do certain tests for themselves. So if a doctor is going to rely only on tests, a lot of them will not diagnose at all. In our continent, it has become an accepted practice, more so, for a doctor to listen to your conditions and deduce that this is what the person is suffering from and put you on medication. That's why it's difficult to prove negligence, because you cannot go and allege that, why did the doctor not do tests before coming to this conclusion, when most doctors can diagnose without going for a test and a lot of patients have gotten better from that diagnosis. So that's the first part of your question. But I guess the main part of your question is this, that if I've forgotten, what was the initial part of your question, please? If you remember. Yes.
I think it was
yes. So, okay. So as I have been trying to say, I think I was talking about the rights. So your first and initial right is to assume the burden on yourself. Number two.
But before the rights, let me ask Dr. Natalia one question. Doctor, do you always look at the patient's ability to pay or to get some drugs before you prescribe certain drugs to certain patients? Because I know even in everything, we have classes of drugs. We have the first class drug, the middle class, and then the low class, which doctors always say that it has the same effect, but the prices are different. So I just want to find out that, lawyer, we'll come to the legal rights, but I just want a clarification on that. Do you always check the ability of a patient to pay? Because in all your submissions, you were mentioning the inability of the clients to pay, don't have enough money, equipment and stuff. So is that a consideration for doctors to check ability to pay before you prescribe?
Okay, so thank you very much. One of the things I learned from one of my consultants is that sometimes you don't even need to ask the patient, just check the patient bedside. There are people who, when they are admitted, they have Milo, they have needle, they have biscuits, they have food, all distributed by their bedside. It just tells you the homes that they are coming from. Others have nothing. So you don't need to be asking, can you prescribe? So there are things you as a doctor, we can just pick up naturally before even asking. Because if a patient has been in the ward for about 10 months, but no relative have come to visit, you don't go and write big prescriptions for the patient to buy. Then for some of the drugs that we administer, it doesn't matter whether they are class A, class B, or class C. Some of them are required for, that is the only drug for management. Example, if someone is bitten by a snake, the anti-venom is one. It doesn't matter whether you are a low class client or a high class client. That is the same drug. All those paracetamol antibiotic we are giving is not the actual cure or treatment plan, is the anti-snake venom. And if Ghana Health Service don't have, then it means you, the patient, who's the burden to get it from places you can get it from. So now the issue of some doctors stocking it, some nurses stocking it, some pharmacists stocking it. Ideally, Ghana Health Service requires that it's an emergency. The system is so loose that people stock it themselves. And so those that patients are even buying half on it. Fully retail, but they will have to buy it from pharmacies. So, do you still hear me?
Yes, your line was breaking, but we can hear you. Go on.
Yes, I'm saying that the patient's rights are many, but of the treatment modalities, first of all, it is better to have a little idea where the patient's economic status is in order to start prescribing, because if you keep doing that, you still can't, the management plan is not done. For example, if a patient is febrile, have high temperature, it can cause convulsion. So if you give oral medication and the fever is still high, you go parenteral. Parenteral is giving the blood through the veins, giving the medication through the veins. Now, paracetamol is about 60 Ghana cedi. So if probably the patient is not insured, the hospital claims that they don't have oral paracetamol because now they don't stock it in their emergency medication, and you think the patient's fever is too high that you need parenteral IV paracetamol, you are going to be there for 72 years. And I want to use a case scenario. How come tests in rural areas are able to manage even without sophisticated gadgets? In the cities, if someone has prostate, ideally, some people would want to have their blood test done to do a prostate checkup to know whether their levels are above 4, to know whether they have a cancer or not. In the village, they cannot afford. So what many doctors do is digital rectal examination, where we put our finger through your anus to check whether the prostate is palpable. That will give us an indication to know that this man is have a prostatitis or probably a prostate C. And so you manage along that line due to your clinical findings, because there's lack of diagnostic investigations to be done. But in the cities, many doctors may not be willing to put their finger in your anus. They will just write a prescription that will come. So those are some of the challenges we also have. And then I also spoke about some case scenario. For example, how come some cases would have been managed by a West doctor, but somebody who is learned mismanage it? One of the reasons why medical doctors don't treat their family is that it makes you biased upon their treatment abilities. I have a case, the hospital, I'm not going to mention it, but this was a relative who was very, very close to the medical director. When this child was sick and brought to the pediatric emergency, even the emergency specialist was there to check the treatment. House officers or saw that this is a case that the child needed to go theater. When father or mother heard that a young child of about 8 or 9 years needs to go to theater, they try to mar the diagnosis that no, don't write this diagnosis. If you write it, it's an indication for us to take the child to theater. So they had to change the treatment modality in order to calm the nerves of the parents. The following morning, the child died. Postmortem done indicated that what the house officer wrote or the junior doctor wrote was actually what was wrong with the child. And some of the things we diagnose, we don't necessarily need laboratory to identify. Some signs and symptoms are classical. For example, to identify that someone suffers from a condition called appendicitis, you must have what you call radiating pain from the umbilicus to the right iliac fossa. You have to divide.
Doctor, this is your umbilicus, nobody understands.
No, I'm breaking it down. I'm breaking it down. For example, if someone is lying on the bed, you realize that the doctor starts touching the stomach from left to the middle to the lateral. So for example, you, the doctor, have an imaginary division. So you divide the abdomen into 9 regions. So you have 1, 2, 3, 4, 5, 6, 7, 8, 9. So on your right side, you have your right upper, middle, and lower. So the lower right side is where it is closer to the waist. So if I touch that area, before that, I'll start touching areas for which you don't feel any pain. But when the hand reaches that particular segment of your abdomen, you feel severe pain. Some of the patients will not even allow you to touch that place. That is an indication of a problem that would require operation if medical management don't work. So if with this clinical evidence, I write that I'm going to start medical management, after which I think this patient should be prepared for theater. And someone comes and says, no, why are you scaring? Because in several hospitals, they don't computerize the system. So the folder is rather given to the parents to go and pick the medication. So while they are going, they open and flip through and read what the doctor has written. So when they see theater, you don't need to know what is it. They know that their ward is going to go to theater and they want to find out more. Right. Some relatives, what they do is that they call other senior colleagues to come and verify whether what the junior colleague wrote is validated. And it gives a lot of problems in the clinical field. So probably the junior colleague may be right, but marrying the diagnosis can also harm the client. So thank you for the opportunity.
I think we spent almost 1 hour, which is the time apportioned for this whole program. So, Lord Edwin, can you summarize in terms of, the rights, you talk about the rights, who has the capacity to sue? If a patient, something happens to my parents, my brothers, my siblings, can I, as a family member, sue? Can a friend sue? Is it my mother? Is it my husband? Who can sue them? Who can sue? That's one. And who are we to sue? Is it a doctor? Is it the hospital? Is it the district, the regional district, or the Ministry of Health? Or I can add all of them as parties to the suit?
Yeah, let me do this quickly. Number one, just finish with the rights. The rights of the patients include, number one, a patient from any part of the country needs to be seen to. There should never be any discrimination. Number two, any patient that presents to any hospital has a right to be told clearly and understandably what condition they have and the risk that are associated with that condition. Number three, if there are alternatives to whatever treatment is available, that also should be made known to the patient so that the patient exercises that choice for him or herself. And finally, every patient, if I talk about rights, then I must talk about responsibility. You have a right to question your doctor about key things that has been diagnosed for you. If a doctor says, go and take this medicine, that medicine, ask him what they are for. Let him explain the condition that he has found, for which reason you are taking this. And all of that will help you so that you can take charge of your own affairs. Now, in terms of suing, if you are alive and something has happened to you because of that, you are the best person to sue. If you are alive, then you should sue, because then you are the best person with the capacity to speak about, and especially requesting for your folder in the hospital and the court making an order for your folder to be given to you if the hospital refuses. All of this, you stand a greater chance if you yourself are suing. But assuming you die, I'm sorry, but in the event that the person who has been treated badly dies, the law makes room for the next best friend. And the next best friend could be the next best person that has the closeness or tightness to the person that can sue for. The father, the mother, the brothers, the sisters, any one of these people can sue, because obviously if the person has died, then they cannot fight for themselves. So it is the next kin or the next closest kin that should do that. The law allows that, even if it is not a very proximate relationship, but it is close enough, that will be allowed, because you are suing for justice for somebody that has passed. I think you wanted to know something else. Yes, who to sue?
Who are we to sue?
Yes, you need to sue the doctor in question, because he is the one that committed the negligence act. And then by vicarious attachment, you bring in the hospital, because it is the hospital that employs him, that gives him the power to work. And like Doc was saying, there are instances when it is actually the absence of tools, etc., which truly ought to be provided by the hospital or the employer, because sometimes the hospital is loose. The employer being the ministry in itself, that is not doing that. That has occasioned the Negligence Act. So all of these people have to be joined to the suit. But more importantly, when you are suing a person, a doctor, whatever money you are looking for, remember that it's not every doctor that has the wherewithal to pay. There are some doctors, when you turn them upside down, you won't nothing will fall down. No disrespect to doc. But if you are suing the doc and the hospital, the likelihood that when you are successful, you're going to get your money from any one of them is what it should be. If it is a government hospital, then yes, of course, you have to sue the ministry, adding the Attorney General, because he's the government's lawyer. You get it? By law, you have a right to sue the government if the government has done something, a negligent act against you. You have a right on that as well. So, I mean, we don't have a lot of time, but I think
I'm sure when the question starts coming, we'll deal with a lot of them. So, Dr. Ofori and then Lawyer Edwin, thank you very much for your time. We have a lot of questions that people have already sent, and then we need to answer. If this is the first time you are joining us, the program is called The Lawyer's Diary. Every week, week in, week out, we discuss very interesting areas of the law. Last week was on types of marriages and distribution of marital properties, and the response was splendid. Our social media handles have been displayed on the screen. On Instagram, we are The Lawyer's Diary Global. Facebook is Lawyer's Diary, and then YouTube is Lawyer's Diary. Kindly subscribe to our channels, like our pages, so that you'll be abreast with our incoming progress. For the upcoming weeks, we are going to discuss issues about will. If somebody wants to make a will, what is the process? We'll discuss, if you don't make a will, what are some of the challenges that you go through if you want to purchase a land, intellectual property. So from commercial law, criminal law, land law, everything will be discussed on this program. Again, we've received a lot of questions. We received a lot of public questions, and then we'll start reading them one after the other. But if you have a question too, you can raise your hand or mute yourself and then ask the questions. The first question was from Akusia, I think in our presentation we answered it. Akusia Jebidonko, she asked that why a doctor through his or her actions leaves a surgical tool in my tummy as a patient and causes me much pain. What can I do? I think lawyer explained that if due to the negligence of the doctor, something causes or a hardship is occasioned to you, you can't sue the doctor. And then there was another question all the way from Canada, from Gertrude Bodu. She also asked that on disclosure, she wanted to find out that sometimes there are instances where the doctors fail to disclose some medications, the effect of some medications that they render on patients, because they know that the side effect of some medications have little or low impact, like giving paracetamol to patients when they know that paracetamol it can be taken even when you are not sick. You wanted to find out that ethically it's not good, but legally to can a doctor do such a thing? So, Edwin.
Yes. Okay, let me answer. Like I said earlier on, a doctor bears a responsibility of disclosing the effects of a treatment or of a drug that he's given to the patient. I think most of the time, because they are stressed out and all of that, they can prescribe and do things without necessarily breaking down the effect to the patient. It is a legal requirement on a doctor, because you need to explain to the person that this procedure that I'm going to do to you, or this drug that you're going to take, these are going to be the effects on you. If he does not do that and the patient suffers as a result of that, the patient can hold or sue the hospital and the doctor for negligence. And in that sense, the negligent act of the doctor has been his refusal to explain clearly to the patients the effect and pain that the patient was going to go through as a result of taking that drug.
All right, so at this point, if anyone has any question that you want to ask, the floor is open. You can unmute yourself or you can put your video live and then ask your question.
Yeah, hello. Hello, lawyer.
So,
hello, can you hear me?
I was on mute. I said if anybody has a question, I have received some videos, hello? But I have a challenge in playing this. So, Dr. Limi, if you are here from Fanoche Hospital, you can ask your question. I'm having some challenges playing the video. So, Dennis, you go ahead, and then Limi to kindly unmute yourself and ask the question.
Can I go ahead?
Yes, go ahead. Go ahead.
All right. So, mostly when we are talking about medical negligence, we only talk about doctors and nurses. But then as of today, we've not mentioned about people who have opened drugstores, and then when patients are not feeling well, they go there to tell them their symptoms, and then they prescribe medicines to them. These people, we don't really hear cases against them. But then Bright Simmons in Ghana have made us know that a lot of people die from such acts. So can those people who have opened drugstores and prescribed drugs to clients be taken on in the matter of medical negligence?
All right, so that will be noted. Michael, do you have any question you want to ask?
Yes, I do.
All right.
Okay, so thank you very much for the opportunity. I think I have a number of questions. First of all, during the explanation, and the questions will go to, I think, Edwin Kusi-Appiah here. Okay. First of all, I wanted a clarification, the difference between medical negligence and medical malpractice. What is the clear distinction? And the second question will be that in your explanation, you made a lot of emphasis on damage or injury as one of the determinants to suing or something like that. And of course, most of the examples were tailored towards the medical professionals and clinicians. But I have a question. For instance, you work in a laboratory. Somebody comes to you to perform a blood group test. Let's assume the person comes and you give the person as O positive. But later, after some number of years, the person comes out that the blood group was, say, AB negative. For this particular case, nothing has happened, no damage has been caused whatsoever. In this particular case, can the person sue based on the supposed error of the diagnosis? And again, you said that one can sue, and I wanted to find out, under which laws do patients sue hospitals or doctors or health professionals? Under which laws in Ghana do patients normally come on when they would want to sue lawyers? I mean, when they would want to sue medical practitioners? Thank you.
Nana Safo, kindly go ahead.
Excuse me?
All right, so Edwin, you can start answering the questions. Nana Safo, you switched your video on. Do you want to ask any question? Edwin.
Special treatment.
I think we lost Edwin on the line. Hello, do you want to ask a question, Nana Safo?
Can you hear me?
Yes, we can hear you now. We lost you. We can hear you now.
Oh, I'm sorry. I'm saying that essentially the first gentleman and the second gentleman asked the same question. You see, the first gentleman was talking about the quack people or selling drugs to people here and there. Yeah. And the second gentleman wanted to find out the difference between medical negligence and malpractice. The clear distinction is this. Negligence is a professional who has the power and a duty to you, who has breached it, and where you have suffered an injury because of that. Malpractice usually deals with where the person does not have the requisite competence to do the duty, but assumes that responsibility. So somebody doesn't have, he has not qualified as a doctor and begins to practice as a doctor. As in the case of those quack people who don't have the competency to sell drugs, etc., but are selling to you. You get it? So I think that is the clear distinction. But in all instances, there are cases where it is a criminal act. Even in negligence, it has a criminal connotation to it. Malpractice generally has a criminal connotation to it as well. If you don't have the license to sell drugs, etc., and you do it, even if you are a pharmacy licensed to sell drugs, but not to listen on the cuff to people and provide drugs to them, you are putting yourself up for negligence and or malpractice. So I think that's the distinction. I don't know whether I have been able to explain it to you very carefully. When it comes to the issue of damage, you said that I spoke a lot about damage, and you gave the example where somebody, a lab technician, says that I am O positive, and later you find out that you are AB after several years. Now, the thing with negligence, as I have been saying from the beginning, you must prove those three elements before you can be given damages for the negligence act. If you are not able to prove it, you won't be given. So if the person misdiagnosed you, but after all these years, you have not suffered any damage because of that, you will not be successful for a negligent act. You need to prove that as a result of him diagnosing you as O, you have relied on it and gone to do other things which have now brought you some problem. And then you can take him on that. So you need to prove the three elements: establish the duty, show that there was a breach, and show that there was an injury to you. If you establish the duty, but you don't show the breach, you don't get. If you establish the duty and show only the injury, but not the breach, you don't get. So it is, and if you are injured, but there was no duty to you, again, you don't get. So you will need to establish all three elements before you are successful in a suit of negligence. And the general law under which negligence is practiced, when lawyers are civil law, you go to court and you plead negligence. Sometimes the matter speaks for itself. Lawyers call it res ipsa loquitur, meaning that the matter speaks for itself. So the burden of proof on it is left as it is for the other person to establish it. And essentially, this is it. If you go to the hospital with a diabetic wound, for instance, on your left leg, which needs amputation, and they amputate the right one, which is unaffected, you don't need to go and prove anything. You just go and tell the court that I want the matter to speak for itself. This is my left foot, which they have always been treating for the diabetic wound. And this is the right foot, which was unaffected, which has now been amputated. So the hospital now has to explain how come that came about. And that is allowed in law. But generally, when you are suing in law, you go under our civil laws and you sue and plead negligence to the court that this is exactly what the doctor did or the nurse did or the lab technician did or anybody who is connected to your well-being did that has been negligent to you.
Okay, so under that, are you by that saying that one comes under the Civil Liability Act?
Well, yes. And do you have any other law?
So I wanted to base on this
common law.
I wanted to make this proposal because I'm a health professional myself. I've tried to go through the laws of Ghana with respect to negligence and some of these things which has to do with the hospitals. And I found out that apart from the code of ethics that health professionals do have and the oaths that we swear to and the patient's charter and the patient's charter and whatever, there are no specific laws which really navigates us towards some of these things. So when it goes to, so I believe that this platform perhaps could advocate for for trying to make an act of assault which would deal with issues of negligence, especially medical negligence and those things very clearly, because clearly sometimes it is difficult to prove. Meanwhile, there is a justifiable means. So that is
Michael, I agree with you 100%. That's why we have said on several platforms that government will have to help establish a body apart from the Ghana Medical Association and the Ghana Nurses and Midwifery Council that takes care of our doctors and nurses. We must have an established body that we report acts of negligence to, and these bodies will have the legal power to investigate and further their ability to testify in court. Because it is very difficult to get a doctor to testify for you, understandably so. And it is almost impossible to, I have never heard the Ghana Medical Association coming to testify for anybody in any civil matter. So I agree. And obviously, invariably, we must have an act governing the way things are done. But not just for doctors, but for all professionals. Even though we all have our code of ethics and the like, we may have a general act that governs the way all professionals work. But more to your point, though, Ghana is like any other Commonwealth country, we are governed by a band of laws. One of them is the common law. And up to now, that's why I painted a case to you. Most of the things that happen are handled by the courts. So there are a lot of decisions on medical negligence by the courts. Some of them, if you have time, Google it and read. I mentioned Jan and Goldfields Limited. There's Kusi-Appiah and University of Ghana hospital. You know, it will tell you clearly how you need to establish medical negligence, what as a doctor, and especially as doctors, what you need to know when you are working as a professional in that field.
So Joe Amon also adds that it appears the conversation has been balanced and discriminatory towards doctors. At what circumstance can a doctor also see a patient?
Yeah, when a doctor becomes a patient himself, okay. If I find it very difficult to see how a doctor per se can sue a patient. I think the first thing that a patient may do to a doctor that may cause him to have a certain relationship with the patient may be where the patient owes money, but you will not owe money to the doctor directly, you may owe it to the hospital. So even if they are going after the patient who becomes well for them, it's the hospital that will do that. Maybe if a patient defames a doctor, where he enters the consulting room and abuses him in a sense that it amounts to defamation, then the doctor can also do that. Or a patient alleged that a doctor has been negligent when the doctor was not, but to the extent that the doctor's reputation has been badly damaged, again, the doctor can sue the patient. So those conditions also arise, but there are not many, as there are where patients have rather been not treated fairly by some doctors.
All right, there's one last question, and I think we can draw the curtain here. Okay, so D also asks that, can other health officials or professionals be sued for negligence apart from doctors, especially when the negligence act was committed by them, as for example, nurses and pharmacists?
I beg you, if we have created the impression that it is only doctors that are negligent and therefore can be sued, then I'm very sorry. Everybody who works in the health can be negligent. And so long as you feel they have been negligent, you sue them. In the Jan case I mentioned, it was the nurse and the hospital they sued, not the doctor. You get it? So you can sue even the lab technician if he does not do his job well. The cleaner in the hospital, who is supposed to clean the floors so that you don't slip and fall. If you slip and fall, you sue the cleaner and sue the hospital as well. So
I mean, sue the security man if he fails to open the gate early. Yeah.
Yes.
But the security man is a man of straw. If you see him, what money can you get?
So that's why you attach his employer to it, so that the employer pays when you win. But the key thing that everyone must know is that today we are talking about medical negligence. That's why we are focusing on doctors and everybody. But everybody can be negligent, because negligence is not limited to the medical field alone. It is in any sphere of life, every professional. You can sue a lawyer for having been negligent when the lawyer fails to advise you clearly and competently, and because of that, you lose a certain case. So any person that owes a duty of care to you and breaches that duty of care to the extent that you are damaged or hurt or injured, either your person or your property, by it, you can sue by it. That's why in the beginning we explained negligence as a tortious act, where an injury that is occasioned to the person of a human being or the goods of the person. So in that regard, you can sue anybody for negligence.
Thank you. We'll take 2 more questions. from our people, and then we can draw the curtain. If anyone has a question, the person can unmute himself, him or herself.
Hello.
Hello, Father. Welcome.
Oh, thank you. Now, I want to thank you once again for this program. Really, really, our learned brethren. I have a simple question. No, I didn't experience this in Ghana, but in Europe, it's about exploitation and temptation. You are with your doctor, and it looks like pharmacists, no, or I don't know whether they are some special shopkeeper. They are always trying to make friends with the doctors to get them to be ordering all kinds of medicines from them. And sometimes they are just oblivious of the fact that we are there and trying to convince them. No. So I have a question for Dr. Nathaniel. Is it really something that happens in your area that there are, from the area of the pharmacists, they are not leaving you to be the ones to program things, but they are trying to influence you to be promoting their trade? Simple question. Thank you.
Thank you very much, Father, for that question. I think in the clinical field, most of the money is in special departments, and one of it is the pharmacy companies. They have lots of money, and many of them have done their own clinical evidences, for which they always want to have a symposium, invite a lot of doctors to come and see evidence available, and always try to pledge their products as superior to any other one. So they have people who move into the marketplace, and sometimes they work with pen, booklets, calendars, t-shirts, and several souvenirs in order to attract doctors to be prescribing their medication. So it is commonplace that many of the pharmacy companies do that. For example, the drug paracetamol has several names. Even though it is called acetaminophen, the pharmacy companies don't write acetaminophen. They rather write Panadol, paracetamol, and several names. And everybody is trying to tell you that this is the quality one. Either it is Panadol, paracetamol, but all you see that the generic name is acetaminophen, but they never write that. And many people pledge their product as quality based on several clinical evidences. And it makes you as a doctor, one way or the other, if you want to consider cost versus convenience versus money, you sometimes have your mind skewed towards what someone did for you. And it may just be because of a diary that he donated to you, and so you want to rather write Panadol rather than paracetamol. So it is commonplace in the marketplace. And then sometimes they don't do that. They come to the hospital to seek for clinical meetings in order to pledge their products. So you find them coming for meetings which may not necessarily be that DS is good than others, but they find a way of market their products to the desktop of the drivers in the marketplace. So they either come to you in the consulting room, they organize symposiums for you to come, or they come to the clinical meetings and pitch their products to us. So it is something that is common.
Thank you very much. Thanks.
Most welcome, Father. So, Edwin, it's a pleasure having a discussion with you. I also learned a lot from you, and I would want to appreciate the knowledge I've had from you. Always when we discuss medical negligence, it's on the basis of doctors being cautious of things we can be sued. I didn't even know that many of our patients don't have the evidence because they cannot prove their damages done to them. And one thing I just want to state is that many doctors can be sued based on breach of confidentiality. I think Dr. Edwin didn't talk about it. And I want to say that you can just sue a doctor because your confidentiality is breached. Probably your identity, your diagnosis is in the public domain, that now someone has COVID-19 and it's a common place. In the hospital, if probably a minister enters and it is quarantined at University of Ghana Medical Center, it just comes out, this minister has COVID-19. It's a breach of confidentiality that that particular person can sue the hospital facility, the doctors, the nurses, but it's a common place now. People don't talk about confidentiality again. So I just want to chip in that. Thank you for the opportunity.
You are absolutely.
All right, and the last question is from Limi Sapon. Limi works at Konfanochi Teaching Hospital in Kumasi. She asks that when there's unavailability of medical instruments or equipment, and in an attempt to improvise, it leads to a complication, can that be termed as medical negligence? That's the last question for today.
Yes, so the question again is, the improvisation, was it out of the training that was given to the doctor or the health practitioner in their ordinary training that they in the training that they got? That's the first question. Would other doctors in that situation have done that same improvisation? And if the answer is yes, it becomes difficult to prove that it was a negligent act. You see, so in order for that anybody to hold that improvisation was a negligent act, one needs to prove that no doctor, having been given the ordinary care, should have used that sort of improvisation in that sort of situation that occurred. If other doctors would have done the same thing, then it doesn't matter that it led to the death of the person.
This is technical.
Interesting.
It's very technical, yes.
All right, so on this note, I want to show our appreciation to our experts today. Lawyer Edwin, Kusi-Appiah, we are extremely grateful for your time and then your expertise, your experience, and your knowledge in this area. I mean, you've proven to us all that from last week and then this week, you are one of the best lawyers in Ghana. We are grateful to have you.
Thank you.
And then Dr. Ofori-Atta too, we are very grateful for your insight. It was just a short notice. I realized that because it's going to be a technical area, we should have a technical person to also share the practical nature of what happens in the industry, and he's done exactly that. To all of you gathered here, we are grateful for your time. I mean, day in, day out, anytime we get the posters out, we see people registering, and it's something which is worth commending. You are doing well. But I will plead with you that, as I've displayed on the screen, kindly go to your Instagram pages and follow us on Lawyers Diary Global. Lawyers Diary Global. On Facebook, it's the Lawyers Diary. And then subscribe to our YouTube channels. On our YouTube channel, every time we do presentations, we record and then put it there so it can be referred. So we are grateful for your time. And then next week, God willing, we'll be coming your way with yet another interesting topic, which I'm sure you love it. It's going to be either on wills or the interstate succession law. So, and then very soon we'll also be doing intellectual property. Recently, Assem, the rap artist, threatened to sue an upcoming rap artist for stealing his concert. So we'll go into that as well. Thank you all for your time. Thank you all for your time, and we are grateful. And before I leave, this program is also sponsored by two companies. The first one is Jibo Kente, Jibo Kente, and then the other one is Enos Travel. Enos Travel, they take you to the world and beyond. So we are grateful and hope to see you next week. Bye-bye.
Bye-bye.
Bye.